Good evening. Welcome to Crossroads Education Series. Tonight's topic is Advanced Directives and Elder Law. Our presenter tonight is Tina Parsley Hughes with Lighthouse Legal. This event is being sponsored by Crossroads Hospice Charitable Foundation. Tina grew up in Southwest Missouri and attended Missouri State University for her bachelor's in accounting and master's in business administration. She moved to Kansas City to attend the University of Missouri Kansas City Law School and received her Juris Doctorate with an emphasis in estate planning in 2004 and her LLM in taxation in 2005. Tina is the managing partner at Lighthouse Legal, an estate planning and elder law firm in Blue Springs.
Thank you. As they said, my name is Tina Parsley Hughes, and I'm very happy to be here. I want to say a big thank you to Crossroads Hospice Charitable Foundation for hosting this education series and for asking me to speak today. As they noted, I am an estate planning and elder law attorney. I've been practicing for almost 15 years now. I've prepared over 2,000 estate plans. So I've got a lot of experience preparing the documents, seeing how they actually work in play. But I also grew up in nursing homes because my mom is a housekeeper in a nursing home and my dad was a janitor in one. So I spent a lot of time in nursing homes and around the senior population, which kind of helped me develop a passion for the group. I am married to Dr. Brian Hughes, which some of you may know, who you may know. So next. We have definition of estate planning. There we go. If you want to go on to the next slide. We're going to start with what the definition of an estate plan is. It's a plan and it's more than just a will. And what it does is it brings peace of mind to you and your loved ones. The basic definition is an estate plan is it controls your property while you're alive and well, make sure that you have control of it, provides for yourself and your loved ones if you become disabled. So you want to make sure that they are provided for as well as yourself if you are unable to handle things yourself. And then when you die, give what I have to whom I want, the way I want, when I want. An estate plan also is used to minimize the impact of professional fees, court costs, and taxes. Who needs an estate plan? Everyone. And that seems kind of silly, but it is everyone truly. Young people, old people, single people, married people, people who have children, people who don't have children, people with a lot of assets, and people with no assets. Most people think that you only need an estate plan if you have money or if you're old and going to die soon. But we'll talk through here and you'll find out why everyone needs some sort of estate plan. And if you don't have one of your own, the government has one for you, and you're probably not going to like what it is. Just to give some background why a properly updated estate plan is important, I want to talk about some people you may know who did not have properly updated estate plans. Prince, the singer that you all may know, died in April 2016. He was only 57 years old, but he had no plan, not even a will. He had no heirs at law, so he had no children and was not married. A guy came out of the woodwork, said that he was his son. They did a DNA test. He wasn't. And then what the statute said in the state that Prince lived in when he died said all the money went to his siblings, many who were half siblings who he didn't even know and probably didn't want to inherit his money. So that's what happens when you have no plan, is the government has a plan for you. And a lot of times it's not one you like. Whitney Houston, another singer, died in 2012, and she did her estate plan before her daughter was even born. And her daughter was 18, Bobby Christina. She inherited over $2 million once she turned 18, and at 21 died of a drug overdose. Can't help but think that if Whitney had had other plans in place, she could have helped her daughter make sure that she was on the right track before she inherited that large amount of money. James Gandolfini, the soprano actor, he died in 2013. He was worth over $70 million, and he did not do any tax planning with his estate. So he paid 55% of his estate to taxes. That should just make you sick to think of that. And most of us probably aren't in those shoes, but Michael Jackson, another famous singer who died in June 2009, had over 600 million in assets. And here he had a trust, so he did the document. He paid someone to draft this document for him, but he didn't fund the trust, which means properly transferring the assets to the trust. So this means everything had to go through probate. There were millions in attorney fees and over 10 years spent in probate before it was all tied up. So that's what happens when you don't have a plan or don't update your plan. When should you plan is the next question. And the answer is now, while you can, before you need it. I have clients who, whenever I do my estate planning, I tell them, when I'm asking them their questions of who they want to designate, I say, if you didn't wake up tomorrow, who do you want to make your decisions for you? And who do you want to get your stuff? There are no second chances. You can't come back from the dead and do this. And estate planning should not be a near-death experience. So the sooner you plan, the better. And as long as you are alive, you can always update and change it. So I always recommend now is the time to make an estate plan. Let's talk about the type of estate planning documents. The ones we're going to discuss today are medical directives, power of attorneys, both financial and healthcare, living will, the last will and testament, and the trust. Medical directives. These vary from state to state. Every state has a living will, which is a document that says the living will is a document that says if you are in a permanent vegetative state, you do not want artificial food and hydration. That addresses if you're in a permanent vegetative state. The healthcare directive, which is something Missouri has, but a lot of states do not. The healthcare directive in Missouri lists 9 things and says, if I am dying and I cannot communicate with doctors, if these things would prolong the dying process, I don't want them. They're artificial food and hydration, there's CPR, there's chemotherapy, radiation, surgery, any of those things. Missouri's was recently upgraded to actually include that you would like hospice care rather than staying in a hospital. And most people, when they know the options of dying in a hospital or dying at home, most people would choose to die at home. The important distinction that a living will and a healthcare directive are not a DNR. A DNR is a do not resuscitate order. And in Missouri, a do not resuscitate order must be signed by a physician. Your living will and healthcare directive do not need to be signed by a physician. Those are usually specific to an entity, so maybe a nursing home or a hospital. These living wills and healthcare directives can be used anywhere in the United States. Go ahead and go to the next slide. And go on one more. Types of power of attorneys. The financial power of attorney is a document that essentially plans for your incapacity if you can't handle your finances. So you are saying, if I'm alive, but I can't handle my finances, I want this person to make my financial decisions for me. You choose when it becomes effective. Most of the time we say it's springing, which means whenever you are deemed incapacitated. But I honestly believe that they should be made effective immediately. Because if you can't trust your agent when you have capacity, you surely shouldn't trust them when you don't have capacity. The types of things this financial power of attorney can do is open bank accounts, sell real estate, create a trust, manage your government benefits, and gift assets. If we're doing some elder law planning, that's actually a really important a component to have in your power of attorney. Most people will say, well, I've got a trust. Why do I need a power of attorney? The reason you need a financial power of attorney is your trust controls anything inside the trust. Your power of attorney controls everything outside of the trust. Retirement plans and life insurance generally are not part of the trust until you die. And of course, you've got your monthly income that's coming in, maybe Social Security, maybe your retirement income. Those are not part of the trust until after you die. So you still need a power of attorney for finances to say who can handle those things while you're alive and don't have capacity. Now, the important thing to note, though, is these financial power of attorneys die when you die. So too many times we get phone calls from people that says, my mom died, she had a checking account, I was her power of attorney, but the bank won't let me have access to it. Say, yeah, that's right. You no longer have access with that power of attorney. Your powers in that attorney die once that person who made that power of attorney dies. The next type of power of attorney in Missouri, we call it a healthcare power of attorney. Go ahead and go to the next slide. Some states will call it a proxy, a healthcare proxy. Missouri, we generally call it the healthcare power of attorney. And these designate who you want to make your medical decisions if you're unable to. They can consent to things like surgery or admitting you or discharging you from a hospital or nursing home. You can generally get these free if you go to the hospital or the Missouri Bar website, and they're usually like a 2-page document front and back. These are okay, but not great. And I prefer the more robust ones, which even include a psychiatric care clause, because memory care patients oftentimes need psychiatric care in order to deal with their issues. And then they also don't always have the proper HIPAA releases in them. So while those 2-page ones are great that you can get for free from the hospital or the bar are great for an emergency situation, proper planning is much more important. And getting a full-length one that has the more robust powers in it is always more helpful. Go ahead and go to the next slide. HIPAA. You've all probably heard of HIPAA, but probably aren't sure what it means. You've probably had to sign a document at your doctor's office or insurance or with your prescription drugs. HIPAA is the Health Insurance Portability and Accountability Act. What this is it's basically a privacy policy. With the modern technology, basically what they've done, what the government did is said, we don't want people getting a hold of people's personal private healthcare information. And by law, no one has access to that information, even your spouse. So signing a HIPAA, what it does is it allows you to release whoever holds that to release the healthcare information to that named individual. This is very important for senior parents, for the elderly, so that their children or their spouse can communicate. But it's also important if you have a teenager who's graduating high school or college and they don't have, and they're going off to college and say they have a car wreck or what have you. If you want to be able to help make those or even have access to their healthcare information and make their decisions, they're going to need a HIPAA release and power of attorneys that give you the authority to do that. Many of you probably have power of attorneys that you've done and wonder if they're still good. The most important reasons to have an attorney review your power of attorney, first of all, would be if you did a DIY, do it yourself. Those things cause many, many problems. You can get them offline for free. And just recently I posted a meme. It had to do with Tiger King things. If you all have seen the movie or the show Tiger King on Netflix. And it said things that I trust more than a DIY will. And one of them was Carol Baskin didn't kill her husband. So we don't put a lot of faith in those do-it-yourself documents, and especially power of attorneys. So one reason you would want to visit with an attorney is to make sure that it is valid. Make sure it complies with the laws in the state that you're in. Every state has different laws. So you always want to check and make sure if you've moved that it will work in your state. You want to make sure it's compliant with HIPAA, that it has releases so that you can get the information you need to. If it's more than 5 years old, the courts do not have to enforce it. So if you have a document that's more than 5 years old, a power of attorney document, you probably want to get that updated just to make sure that the person you want to make your decision can still make your decisions for you. And also it's important when we're doing our gifting planning or our irrevocable trust. And that we'll talk a little bit more about later when we talk about Medicaid planning and veterans benefits. So why do you need a power of attorney? One thing that I already mentioned is that just because you're married does not mean your spouse is automatically allowed to act. The biggest assets that people have individually that are not owned with their spouse are generally retirement plans. And that's because for IRS purposes, they can only be owned by one individual. So If your spouse needed to access those funds or access your payments, they would have to have a power of attorney for finance or go to court and get guardianship and conservatorship. So it's very important that you have these documents in place, because guardianship and conservatorship is an expensive process. And right now it can take up to 6 months, but generally it takes 3 months in order to get a guardianship or conservator process in place. So again, it's always better to plan, and it's always cheaper if you plan ahead. The next document I want to talk about is your last will and testament. This is different than a living will. As I mentioned earlier, a living will is just an expression of your beliefs that if you are to die, you are dying, you're in a permanent vegetative state, you don't want artificial food and hydration. A last will and testament is your instructions about how you want property to be divided upon your death. It designates an executor, or what we call in Missouri, a personal representative. It can also be used to designate a guardian of your minor children, but it is for probate. So the most important thing for people to know is a will is for probate. And like I said, it designates who you want to get your property. If you don't have a will, the government has a plan for you. And in the state of Missouri, the plan is your spouse gets half and your children get half. That's usually not what married couples want. A lot of times married couples want to leave everything to their spouse. And if you don't have a will that says that, that's not what's going to happen. The next documents that we're going to talk about are trust. And there's several different types of trust. The most common are testamentary trust, revocable trust, irrevocable trust, and special needs trust. We'll start with testamentary trust. These are trusts. Go ahead and go to the next slide. These are trusts that are contained in a last will and testament. That's why they're called a testamentary. They are effective upon death and generally subject to probate. These are usually what our young couples use that are life insurance rich. Usually these younger couples have, hundreds of thousands, maybe millions of dollars in life insurance, but not a lot of cash in hand today. And they want to make sure that that life insurance money is used for their beneficiaries, for their children, rather than leaving who they want as the guardian as the beneficiary of their life insurance policy. They can leave a testamentary trust and leave it to their children in a trust. Now, we recommend these for these couples because it saves the money it's cheaper than doing a full-blown trust, which we'll talk about next, but it also makes sure that you're not leaving the money, your life insurance, to someone who it's then subject to their creditors or Medicaid or something else. Next is the revocable living trust. This is the most common type of trust. And the way that I usually try to explain this is think of the revocable living trust as a bucket. And if you're married, it's got 2 handles. If you're married, you've got the 2 handles, you both manage and retain control of those assets. If one of you becomes incapacitated, the other will manage that bucket alone. If one of you dies, the other will manage it alone. And if both of you become incapacitated or die, your successor trustee just steps up, grabs a hold of the bucket, and manages it. Revocable means exactly that. You can revoke or amend it. Sometimes it's revocable upon the death of the first grantor, and sometimes it's revocable if it's only revocable until the first person dies. The nice thing about a revocable trust is it is private and there is no court involvement. A will is all public. Anyone can go to the court, pick up a copy of the will, find out what kind of assets are in there. A trust is private. Nobody else gets to know what's in there except for the beneficiaries. You can provide protection for the beneficiaries with the trust. There's a lot of different types of ways you can protect beneficiaries. You can have credit protection in there. You can have divorce protection. Say that they have a drug or alcohol problem, you can help protect against those problems. And it is countable for long-term care purposes. So when we talk a little bit later about Medicaid and veterans benefit, it is an asset. Because it's revocable, it is included an accountable asset. Irrevocable trusts. They are very powerful trusts that can be used to help protect your assets if you need long-term care in the future. Generally, these cannot be amended by the grantor. Missouri has some flexible laws where we can do some creative things, but not typically. They're irrevocable, as the title states. We use these a lot of times for veterans planning, Medicaid planning, any sort of asset protection planning, or federal estate tax planning. Right now, the federal estate tax, you are not charged federal estate tax if you have an estate smaller than 11.4 million. So we don't use these as often as we used to for federal estate tax planning. But if you have an estate over that, this is one vehicle we can use to help minimize taxes upon your death. These are not countable generally for long-term care purposes. So this is one reason we use these a lot in our Medicaid and veteran benefit planning. And they also can offer creditor protection. So if you have one of these and you put your assets there, and then later on you're in a car accident or something like that and you're sued, this can generally offer you protection from that. The last type of trust that we are going to discuss is a special needs trust. One of the worst things a person can do is leave someone who is receiving needs-based benefits, so Medicaid or Social Security, SSI, leave them assets, especially leave it outright. These benefits are generally that they receive are subject to how much assets the person has, the person who's receiving it. For example, early in my practice, a client who had their trust drafted with someone else left their granddaughter with Down syndrome about $200,000. This granddaughter was 28, was living in a group home. It took her 4 years to get into that group home because of the wait list. And once she received that inheritance, she was kicked off Medicaid, had to leave the group home, spend down the money, and then reapply. So that is not what you want to have happen. So special needs trust is established for a person who has disabilities and is likely to or is receiving any sort of needs-based benefit. It allows that person to receive the inheritance without disqualifying them from those government benefits. And then the trustee is managing those trusts at the discretion of the trustee. So it's a complicated area. You definitely don't want to try to do it yourself or just go to someone who is a general practice attorney for these. But it's a special kind of trust that can help if you have someone who is over the age of 18 and has any sort of disability or special needs. So that's the basics of estate planning. Next, I want to go to, I'm going to first check and see if we have any questions. Brian, do you have any over there? Do you know what this was in reference to? Healthcare directive? Okay, someone had asked a question back on the estate plan. Someone had asked a question that I want to go back to about living will and healthcare directives. Those are different for every state. And like I said, Missouri, every state has a living will. Missouri has their own healthcare directive. It is different from what you get in Kansas, and it's different from what you'll get in any state. So if you are in a different state, you need to check and see what your state has and what they offer. And I think that's the only question we had so far regarding that. All right, let's talk about Medicaids and nursing homes. Most of the time when I have seminars, and my seniors attend these educational seminars, it's because they want to learn how to keep the government from taking their assets. And this is usually in regards to long-term care. And keep in mind, I'm going to discuss the basics related to Missouri law. But first I want to talk about the cost of long-term care and some statistics and why this is so important. Here in our area, in the Kansas City area, the average cost of an assisted living facility is $3,600 a month, and a full-scale facility is about $6,200 a month. Memory care units are even higher than that. Now, I have friends all across the United States who participate, who do elder law with me, and they pay anywhere from $15,000 to $20,000 a month for long-term care. So we are really blessed that our rates are not that high. Be that as it may, those rates are more than what most people can afford. Just a few more statistics. 47% of men over 65 will need long-term care. 58% of women over 65 will need long-term care. 48% of those who will go to long-term care will need it for a year. 19% will need it for 1 to 2 years. 21% will need it for 2 to 5 years. and 13% of people will need long-term care for more than 5 years. I have one client whose mother has been in a nursing home with dementia for 18 years. So as you can imagine, that has become incredibly expensive, and they have had to rely on Medicaid in order to pay for that. And that's because only 11% of adults 65 and older have long-term care insurance. So if you don't have long-term care insurance or cash available to pay for your long-term care, most people are going to rely on Medicaid. As I said before, this is Missouri law. Missouri and Kansas law is very different. While Medicaid is a federal program, the money is paid to the state, and each state interprets their laws on their own. So these rules are for Missouri. Missouri refers to Medicaid as Mo Health Net. So if you hear that, that's what we're referring to. And most people needing long-term care eventually qualify for Medicaid. Currently in Missouri, 2/3 of nursing home residents are receiving some sort of Medicaid benefit. Do not confuse Medicaid with Medicare. If you don't practice in this area regularly, you do not usually know the difference. Medicaid is aid for the poor. Medicare is a benefit that you qualify for from paying into Social Security. Currently, once you turn 65, you qualify for Medicare. Medicare only pays for nursing home costs related to rehabilitation services. So if you've fallen and broken your hip or something like that, and you're going to rehab in a nursing home, they will pay for up to 21 days, and then you have a copay after that for, I believe it's the next 100 days. But they do not pay for long-term care. So most people think their plan is Medicare. It's not. They're sadly mistaken. Medicaid nursing home benefits is called vendor benefits. It's a different type of Medicaid than if you're living at home in the community and needing Medicaid. It is subject to asset and income limits, as well as having exempt and non-exempt assets. Go ahead. So examples of the exempt assets, and again, this is Missouri, Kansas is different. In Missouri, your home up to $595,000 in equity is exempt. One automobile per household, a prepaid funeral plan, and currently up to $4,000 per person. So a married couple can have $8,000. I do want to note on July 1 of 2020, that is going up to $5,000 per person. But currently, as of today, it is at $4,000 per person. Anything that is not exempt is considered non-exempt assets. Anything that's considered non-exempt is part of the pot to pay for your care. Next, income. Each spouse is entitled to keep their own income. So if we have Joe and Mary, if Joe earns $5,000 a month and Mary earns $400 a month, Joe gets to keep all of his money, but Mary's money, her $500 a month, is going to follow her to the nursing home. Now, if it's reversed and say that Joe is going to the nursing home and Mary is staying home, we can reallocate some of Joe's money to Mary so that she's not living in a cardboard box. And we call that mana. So if you see, you'll see I've used some initials here in this PowerPoint. IS is the institutionalized spouse. CS is the community spouse. So community spouse is the one that's usually staying home. Now, for married couples, this is when we have a lot of planning opportunities. But generally, the rule of thumb is you gather all the countable assets, so the non-exempt assets, no matter whose name it is, gather it up, divide it in half, and the community spouse gets to keep half. However, they can keep a minimum for 2020 of a little over $25,000, and only a maximum of $128,000. These change every year, but the other half or anything more than that has to be spent down. So as you can imagine, if you have a married couple who has a significant age difference or significant health differences, planning can be essential, because if you have a 65-year-old whose spouse is going into a nursing home and they're told you only get to keep $128,000 and they could live to 100, it would be essential to make sure you get some sort of plan in place in order to keep more of that money than what the government will let you through normal planning. Oftentimes when I'm talking with seniors, one of the things they say to me is, well, my mom or dad just signed the house over to me and then the next day moved into the nursing home. Yeah, the government caught on to that. And so because of that, they instituted a 5-year look-back period. This is a very strict rule in Missouri. If any gifts over 500 generally will have a transfer penalty. And you can't get around it just by selling your asset cheaply to your kid. So for example, you can't sell the family farm that's worth $1 million to your kid for $100,000. It has to be at fair market value. Every sale transaction you've made in the last 5 years for an asset has to be reported to Medicaid, and you have to give them the supporting documentation. And don't think that they're not going to find out about it, because they do. I inevitably have clients who forget about something, forget about selling a car or something, and they will find that information. And if they find that information and it was transferred and causes a penalty, then they will imply that penalty. So for every $6,463 transferred, that causes 1 month of ineligibility. So gifting assets can be a really difficult way to try to preserve assets. Now, there are some things we can do, but in order to protect your assets, every case is unique, and you can't always do what your neighbor did. This is the one thing that I always stress to my clients is, their sister did this or their aunt did this or whatever. Again, every state is different, and depending on the asset types you have, everything is different. So I highly recommend, if you know nursing home care is in your near future, you consult an elder law attorney before entering a nursing facility. So much of these plans that we put into place all have to do with the timing. And some of the things we pay before you go into nursing home, some of them we wait until we get a snapshot date and you moved into a nursing home, then pay for things. So it is so important to consult with an elder law attorney before entering a nursing facility. The sooner you plan, the better, because otherwise we end up in crisis planning, which can cause a whole lot of issues. So most clients are going to end up using Medicaid to pay for their long-term care. But another benefit that's available are veteran benefits, specifically the aid and attendance pension. I am veteran accredited and can assist with qualifying for these benefits and applications, and most elder law attorneys are as well. There were major changes made to these benefits in October 2018. So if you applied before that date or know someone who applied before that date, these requirements are going to be different. So keep that in mind. The basic requirements to qualify for these pension aid and attendance, which is basically a monthly pension that can help you pay for medical care, whether it's in-home care or a facility, independent living, assisted living, full-scale facility. So the first requirement is you must have been 90 days of active military service if it's prior to September 7, 1980. If it's after that day, you have to have at least 24 months of continuous active coverage. Most of our clients are at the 90 days. You must have served 1 day of wartime. And that will be on the next chart where we will look at what time period the government designates as wartime periods. It's very specific. Your discharge must be something other than dishonorable. So as long as it's not a dishonorable discharge, you will meet this requirement. You must be disabled, which we will address later, the definition of that, and you must meet the asset and income test in order to qualify. So those wartime periods, I've got those up here, and they are very date specific. It does not matter, in most cases, it does not matter if you left the United States or not. If you were in the military and served 90 days and served at least 1 day during these time periods, you are eligible for these benefits for that purpose. Now, Vietnam is the only one that gets a little tricky. They have a boots on the ground date that is extended more than those who did not have boots on the ground in Vietnam. And Gulf War, you'll see that it started August 2nd, 1980 to question mark. And that is because we are still at war. For all intents and purposes, we are still at war, and the government, the president has not established an end to that Gulf War date. So all those veterans who served from 1980 to present will eventually qualify for this pension. How can you find out wartime periods? This can be found on a DD 214. That's your certificate of release or discharge from active duty. Anytime you leave the military, you are given this document. If you have trouble finding this document, you can go online and request this document. In order to apply for these VA benefits, you must have an original DD 214 to apply. So the next test we talked about was the disability test. If you are 65 or older, you are automatically deemed disabled for this test, which kind of can be insulting to think that just because you're 65, you're deemed disabled, but you meet the disability requirement just because you're 65 or older. Also, if you are permanently and totally disabled with it doesn't have to be service connected. And the way they determine if it's permanently and totally is that they are reasonably certain that disability will continue through life. So if you had an accident and you became an amputee, a double amputee or something, this would likely cause you to be eligible for these benefits if you were under 65. But if you're 65 or older, you automatically qualify and meet the disability test. Like I said, with Medicaid, there are financial tests that you have to meet in order to qualify for the benefits. We want to go ahead and go to the next slide, the financial test. So there's an income test and an asset test, just like with Medicaid. Now, just like with Medicaid, there is now a look back. Prior to October 2018, there was not a look back. Now there is a 3-year look back beginning October 18, 2018. Similar assets are excluded, just like with Medicaid, except they are more definite in that it's a house and 2 acres and 1 vehicle. So those are not included in the amount of non-exempt assets you can have. So for assets, you can have, and this changes yearly, it is not the same as what Medicaid is. So it makes it extremely confusing. But for 2020, it's $129,094. That's the total assets, whether you are single or married. Prior to these new rules in October 2018, we did not have a bright line limit for all applicants. It was up to the discretion of the person reviewing the application. So it's really nice to finally have a guidance of how much the assets it can be. Now, the income test is a little bit tricky. It is what we call IVAP, income for VA purposes. And what they do is they take your gross income, subtract out your unreimbursed medical expenses, and that is your IVAP. So, for example, if you have $10,000 of income a month and your expenses for medical expenses are only $2,000 a month, your IVAP, income for VA purposes, would be $8,000. Because that's greater than any of the benefit amounts that you could qualify for, you're not going to qualify for anything. The maximum amounts for 2020, I have listed here. Keep in mind these change every year. So you'll see a veteran with a dependent or spouse qualifies for the highest amount. A single veteran qualifies for a significant amount. But you also see there a surviving spouse. This is probably the most underused benefit in veteran affairs. The VA aid and attendance for the surviving spouse. Most people do not realize that just being married to a veteran and having been married to them when they died, if they would have qualified for this benefit, you qualify for this benefit. You don't have to have been married to them when they were in the military. You do not have to have served yourself. You can qualify based on their benefits. And that $1,230 a month has helped so many of my widows be able to move into an independent living or an assisted living facility. So this is one of my favorite programs to help people with and help them qualify for. The other thing I want to mention about these pensions is that they can be used to pay a family member, a spouse or a child or anyone to take care of you in your home. So these are huge because this can really help pay for someone to stay at home rather than go to a facility. And we can help you with those veteran and Medicaid approved caregiver agreements. You have to have a veteran approved and Medicaid approved caregiver agreement in place to do that. But in doing that, you can really help get some money to help pay for your loved one to stay at home rather than having to move to a nursing home. So the most important takeaways here with the VA is the veteran does not have to have been hurt in service in order to receive benefits. That's what most people think. They do not. They do not have to be injured in any way in order to receive those benefits. And that the surviving spouse may qualify for benefits. It's really, really important and can help because the women oftentimes by statistics survive the men and they oftentimes need these benefits. And then the last thing, just say no to annuities. If you're a veteran, I guarantee you've been solicited by an annuity salesperson. Luckily, in 2018, those new rules banned annuities. So we no longer have to deal with annuity salesmen pushing these annuities on our veterans in order for them to qualify for these benefits. If anyone contacts you about an annuity for veterans benefits, just say no. That is probably the best piece of advice I could give you today. Now, before we end, I want to discuss quickly the temporary remote notary statute that Missouri passed. So the governor of Missouri passed a temporary remote notary statute that is effective until May 15th, 2020, when hopefully we will be allowed to actually see each other again using socially distancing. This statute, from what we understand, allows notaries to use video real-time video in order to notarize documents. We are unclear on whether it allows witnesses to be available via notary. The stance and position my office is taking is interpreting it very broadly. And we are interpreting it to say that the witnesses can be one location, the notary can be one location, and the signer can be in another location. And then what we are doing is after this crisis is over, re-signing the will. That way we know it meets the requirements. Now, we did have a question that just came in. Do the VA benefits for the widowed spouse end if the surviving spouse remarries? And that answer is it depends. There are some new rules on this, and it depends on how long you were married and how long you've been married to your new spouse, at what age you got married. So that's one of those things where those are very specific sets of circumstances. And we welcome you to reach out to us. And if you give us that information, we can tell you. That kind of brings me into my next thing. The most common question I get from clients, and anytime we do these presentations, and again, thank you Crossroads Hospice Foundation for having me. I really appreciate this and I love to educate people. But the most common question we get is, how much does it cost? We meet with our clients for free. The first client appointment is free. And that's how we do our things. And that's because we don't know what you need until we meet with you and find out what you have and what you want. So once we meet with you, we do our initial consultation. We will meet with you to figure out all the information that we need, and then we can tell you what we recommend and what it costs. So right now what we are doing, and I believe most attorneys are doing, and at least in Missouri, we are doing phone calls or Zoom meetings similar to this in order to get to know our clients. We are always available, and if you come and see us and you have a case and it's something that we can't help you with, we are not going to charge you. Even if you don't come to us, I recommend that you contact a skilled elder law attorney if you need any information on the Medicaid or the veteran benefits. This, unfortunately, is a very sensitive area, and it's not something that you want your attorney who does your traffic ticket to handle. Likewise, if you were to come to me and tell me that you got a DWI and need assistance, I would be of no help to you. I stick with the estate planning and elder law, and these other attorneys usually stick with what they know and what they're good at. So now at this point, I want to open this up for questions. Do we have any questions coming through? I know we've got a little bit of a lag, so. Someone asked if they could have a copy of this PowerPoint presentation. I believe they will make this available, the foundation will make this available on their site, and if they could post that information, that would be great. Someone asked if we travel. Yes, we do. We oftentimes make home visits and nursing home visits, especially when we're working with our medically frail seniors who can't leave the home. Nursing homes, hospital visits, home visits. And I generally will travel most of the state of Missouri. I grew up down in Ozark, Missouri, so I'm going down there usually once a month whenever I'm not restricted from traveling. But I travel generally anywhere we need to help our clients. And if I can't, I can refer you to someone who can, that's close to you. Okay, somebody had asked a question that said, if they have a relative or next of kin that lives out of state without any legal documents in place, what would be the first steps to take if that person can't speak for themselves? If that person is already incapacitated, it is likely that person is going to need to get guardianship and conservatorship. So if that person does not have the capacity to sign these documents themselves, they can't understand who they are appointing and sign those documents, you're probably going to need to contact a local attorney and find out what their guardianship and conservator process is. That's another one of those things that's completely different depending on what state you're in. Someone asked, their mother wants to know how to add one of their children to their home and if there's any special rules for that. So a couple things I want to say on this, and this is a great question because it's one I get all the time with my aging seniors. Be very careful about currently adding your child to the home for a couple of reasons. One, we have that 5-year look back. So if you do that within 5 years of needing nursing home care, putting your child's name on any account, checking account, savings account, house, any asset is going to be deemed a gift. So you have to be careful with that. The best thing to do is likely to do a beneficiary deed where it says, upon my death, this child gets the home. Now, if you want to preserve that house for your family for long-term care and keep that money from having to be taken for long-term care if you go to a nursing home, that's where our Medicaid Asset Protection Trust can come into play and help preserve that asset and make sure that, you know, the family farm or something that you've had in the family for a while can pass down and not be subject to Medicaid. And someone just asked about putting their house TOD. In the state of Missouri, and not a lot of states have this, so in the state of Missouri, TOD, that means transfer on death. But Missouri, you can do what's called a beneficiary deed. We prepare those for clients, and most attorneys can prepare those. I would not do it yourself because if you mess it up, then it ends up in probate. While we're waiting for some more questions to come in, I'll go ahead and touch on what we call non-probate transfers. And these are transfers that avoid probate, so basically non-probate. POD, payable on death, TOD, transfer on death, or beneficiary designations. That's what those are. Those are very important tools that you can use to avoid probate. The problem with those, though, sometimes is if you're leaving anything to a minor or if that person dies before you. So that can create some problems. One of the things that my clients do the least, and I know why, they hate going to the DMV, But on your vehicle, whenever you're buying your vehicle, when you're in the finance and insurance office and they're filling out the title work, you can have them right there, put in who you want that to be transferred to on death. That way it will avoid probate. Now, if you have a loan against it, unfortunately they inherit the vehicle subject to the loan, but at least if there's equity in it, they could have it. And if there isn't a loan, then they can keep the vehicle. This can be done with checking accounts, savings accounts, and any kind of accounts that you have. If you are named on the account, so here's what some parents will do is they will go ahead and put they'll put one kid on the account. So say mom has 3 kids and she names the son on the account. Her intent is that son will divide the assets equally between his 2 sisters, him and his sisters, when mom dies. He doesn't have to. If son's name is on that account as a joint owner, they get it outright when you die. That's why that designation, adding someone as a joint person on that account, can be troublesome. The other reason is for credit issues. Say, for example, your son has an accident, has a motor vehicle accident, hits and kills someone. That is an asset that can be used to pay any claims against him. So that's why we don't like putting our children on our accounts while we are alive. And same reason why you shouldn't be on your children's accounts. I always tell parents, when your kids turn 18, get that car out of your name. If it's paid off, give it to your kid, transfer it to them. Because if they get in a car accident and your name's on that title, you can be liable just as much as the child. Great question. Is there any difference between unmarried long-term couples and elder law? Yes. This comes up. There's a lot of clients I have that actually will not get remarried. When they get older, maybe their spouses have been deceased and they choose not to get remarried, but they live together. It's very important to make sure that if the house is in one person's name, that you have a plan in place so that other person does not become homeless or get kicked out of the home. So we have some unique situations, some unique planning strategies we can use there to make sure that your significant other is provided for. And even more so, the reason you want to do planning is if you do want to provide for them. By the state law, if you're not legally married, they are not provided for. They don't get anything. So if you want that person to be provided for, you need to have something in writing. And unfortunately, this last year, we've had a couple cases that very similar to that, where the couples were together nearly 20 years. They had lived together. All their assets were intermingled. All the assets were in the man's name. He had a car accident and died, and the assets all went to his kids. His kids did not do the right thing and give the money to the significant other. And that's one of the things unfortunately, that goes along with the 2 things that we have to say nearly every day to clients. And the first thing is, don't expect people to do the right thing, because unfortunately they don't. And the second thing is, pardon my French, but people are assholes. People do not always do the right thing, and they will do what is in their best interest. A lot of times that's because of what we call the daughter-in-law problem. And that's, I'm not worried about your son. I'm worried about his wife telling your son what to do. And I can say that because I am a daughter-in-law. So my mother-in-law might even be on here, and she can tell you I'm the troublemaker in the family. So, but yeah, we call that the in-law problem. So that's one reason why proper planning, we can help you avoid those situations and make sure that if you are in a long-term relationship and you want to provide for your significant other, it's very important to get a plan in place, because otherwise they're out of luck. All right, are there any other questions? I'm not seeing any other ones. Well, again, I just want to thank you all very much for joining. I'm sure some of these people are my parents, so hi Mom, hi Dad. I'm sure you guys are watching home from Ozark, Missouri. And you'll see that we would appreciate it. There's a link here in the comments. If you would please share feedback. We always like to know how we can do better, how I can do better, what I didn't address maybe that you would like addressed. You know, I make these presentations based on my experience, my 15 years now of experience, but, you know, based on what people ask, but that's always changing. So I am definitely always interested in hearing what questions you have. Okay, one more new question came in. If a person gets married but does not add their spouse to the home, is the widowed spouse entitled to that asset? That's a tough one. It depends, and that's the typical lawyer answer. It depends. That's one reason why when you get married is a time to make sure you update your estate plan, so you put that person on the title if that's what you want. In the state of Missouri, if you do not have any sort of plan in place, then what will happen is the spouse will get half, and if they have any children, if the deceased person has any children, they will get the other half. That's the general rule, even if you have children in common. So I'm actually dealing with that with a client right now. Similar situation, she had refinanced her home recently, and for some reason, her name wasn't on the title when they refinanced the house, and husband died, and now we're having to do that. We're having to probate it so that she can get it. And we are hoping in this situation, his kids will do the right thing and turn around and sign that title of the home over to the spouse. But you cannot always guarantee it. All right, I think that is it for the questions. Thank you all very, very much. And again, thank you to Crossroads Hospice Charitable Foundation for having me.